Welcome to the state of Montana's training video for facilitating pre-hearing conferences in DN cases or child abuse and neglect cases. My name is John Gwynn. I'm the intensive case manager for child and abuse and neglect cases in Yellowstone County, Montana. I have been hired about a year ago to do this job. The primary purpose of my job has been to conduct pre-hearing conferences in DN cases. I have been doing so for about 14 months at this point. This all came from a pilot court project that is being run out of Judge Ingrid Gustafson's courtroom. The idea has been to build a team of professionals to work together to find new ideas and better ways to facilitate better outcomes in DN cases. The project has been going on for a couple of years now, and I was brought in to put on the pre-hearing conferences after about 2 or 3 years of this going on. The professionals within the team are the attorneys who are representing the parents in the case, the guardian ad litem who represents the best interest of the children, as well as the professionals from the Department of Public Health and Human Services. The goal behind these pre-hearing conferences is to have us sit down in a room, have a discussion, and begin a plan for reunification of the family. At the beginning of DN cases, except in the most extreme circumstances, all of the team members have the same plan, which is reunification. There may be differing views about what needs to be done, how long that would take, but the goal remains the same at the start, and that is an important thing to remember and perhaps remind members of the team of during a pre-hearing conference. My job entails not only putting on pre-hearing conferences, but as part of the pilot court project, we have expanded to all of the courtrooms in Yellowstone County. I also mediate cases when important issues arise. Either a party can request a mediation or a judge can recommend one. I also keep statistics with regards to the case, so I am aware that we have shown improvement through the pilot court project. The judge takes a much more active role in our pilot court project cases, and I'm going to encourage you as the new facilitators out there to encourage your judges to do so. One simple way to do this is to have status hearings throughout the case every 60 to 90 days or so when there aren't hearings, and simply to have a short discussion about how the child is doing, where the child is placed, what are the needs of the child, how are the parents doing, what do they need to be working on, and what can the Department of Public Health and Services do to help them in that process. It's a very simple process, and I hope that you encourage your courts to do so because it will improve this process. The pre-hearing conference is only a beginning of the discussions, and it is designed to be that and designed to have ongoing discussions. Status hearings are one of those. The other thing we work with in our county, and I hope you do in yours, are team decision-making meetings and family group decision-making meetings conducted by professionals. In our county, these are done out of the offices of the Department of Public Health and Services. I share the information I've learned through my notes with the professionals mediating or facilitating those meetings over at the department in the hopes of building and going forward with the ideas and plans we've begun with this case. Purpose of the pre-hearing conferences. Why do we hold pre-hearing conferences at the beginning of a DN case? The primary reason, and the first reason listed in the slides here, would be to establish trust between the parties. The thing that you have to remember is you're in a room with people, some of which removed a child from a family, and then the members of the family who had the child removed. You are often in a situation where there may be outright hostility between the two parties, the Department of the Child Protective Services people and the parents. You're in a situation where immediately you must establish trust. I do not dress as I am today. I dress in a much more casual and friendly manner when I'm doing this because I don't want to feel like the court. I don't want to feel like somebody who's in charge of these people's lives. I'm just here to facilitate a discussion about how we can make the home safe and how in the future we can get the children home. If you don't have that sense of trust between yourself and the parties at the start of the case, you're not going to make progress. And that is the most simple purpose that we have here and the most important one. And it needs to be built throughout the pre-hearing conference so that it can go forward after the pre-hearing conference. I know I've been successful. When I finish, I'm leaving and I find the parties in the hallway discussing further issues on the case, because I know things are going to move forward. The second purpose that I've wrote down here is to give everyone an opportunity to speak and to be heard. And again, this is a very important purpose behind this. Often, people feel that they don't have a chance to speak. The caseworkers have expressed the opinion to me that sometimes they feel the lawyer won't let them speak, that in the case here, a county attorney will not give them an opportunity to really speak up and say what it is they believe. And in the end, this really isn't about the lawyers. It's about the social workers trying to move the case forward and the parents trying to make progress. The other group that feels like they don't have a chance to speak or to be heard are the parents, and I think that's probably an obvious one to you. There are often people who are having trouble in their lives, whether it's drugs, mental capacity, mental health issues. Their children are removed in what is often a chaotic, highly charged environment. They have quick discussions. This is a chance to sit down for them in a room where things are calm and structured and really express what it is they think. What is it they want to be heard? Something you need to be careful of is that they'll often want to talk about the removal and whether that was justified. And that's really not the purpose of our pre-hearing conference. Our purpose here is to try to get parties to move forward from this point and to seek a resolution that is safe for the child. So giving everyone a chance to speak, ensuring that everybody is heard, is a key role and key purpose behind facilitating pre-hearing conferences. This leads into really the next purpose, as I've listed here, which is encourage everyone to listen and to consider the points of view of other parties. It is one thing to have a chance to speak and be heard. It is another thing to actually sit and listen and to consider. And that can be a very hard thing, particularly for the social workers and, again, the parents. The social workers have made a very difficult decision, and you can't underestimate how hard it is for them to actually have removed a child and what thought and feeling went into that decision. And you must give some credence and thought to that because they feel very strongly about their position. And having them open up to other ideas can be difficult, and I can understand where it would be hard for them. From the parents, they're often in a position where they don't realize how serious the problems are in their home. It may have deteriorated slowly over time. They might have mental health incapacity issues. They might be under the influence of drugs. Encouraging them to listen, finding points within the meeting to discuss issues and ask people about something that was just said, to ensure that people are actually listening to what's being said and giving due consideration. That doesn't mean that everybody agrees to everything. But if we can do, as they said in law school, have reasonable minds differ and listen to each other, you've made huge progress in one of the purposes of a pre-hearing conference. Now, the next one I've listed is foster open and honest discussions regarding steps needed to create a safe environment for the children. And this is kind of the structure, the purpose behind the meeting. It's not only to have some kind of touchy-feely a session where we're just laying everything out there, but having a structure to it. That it is looking to develop a home where the children can safely return. You're going to have occasions, and I have them every day, in which people stray. They go off topic, and they forget the goal. It's often crucial as the facilitator to bring things back and remind everybody that the idea is to score a goal or get a touchdown. And where is that? Talk about things that are progress and moving forward to that ultimate goal. It's okay at times to let things stray a bit, but as the facilitator, one of your main purposes is to keep things focused, to keep the discussion focused on a safe return to the home. The next thing I've listed here is to discuss key issues for reunification early in the case. Oftentimes, the pre-hearing conference is the first opportunity people have to sit down and to talk about the case. And you cannot forget that. In our county, ideally, we have team decision-making meetings that happen within 72 hours of removal. But quite often, those don't occur. And the reason they don't occur is parents are not available, or the situation is too hostile, or both parents can't be in the same room at the same time. So often, you're the first person that's really sat down with these people to discuss the case, to have an opportunity to understand what it is the purpose of a DN case is, and that in fact everyone's goal is the same, which is reunification in a safe home. Now, a pre-hearing conference, as they've been designed, are to discuss certain specific issues. The one we remove is we don't really discuss the reason for removal. We discuss the placement of the children, visitation with the children, and services or treatment for the parents and the children. You need to emphasize that multiple times throughout a pre-hearing conference. That's part of the structure, bringing people back, compartmentalizing the discussion. We're going to talk about placement. Now we're going to talk about visitation. Now we're going to talk about mother's services, father's services, children's services. It allows people to focus the discussion. Now, obviously, there's going to be some crossover. Visitation and placement is a classic one. How is it possible to have the visitation with the current placement? But the more you can compartmentalize thought and discussion, the more likely you are to come up with ideas to improve all of these areas. And that is one of the key purposes here, is to find, is the current placement a good placement? Is it the best placement? Are there other options for the placement of these children? Is visitation happening yet? Because it's early. What do we need to do to get visitation started? Are there better ways to do visitation in this case to make sure that the children know that their parents are all right, that their parents are working? And finally, services. One of the huge keys to a DN case, particularly from the perspective of Child Protective Services, is what things do the parents need to be working on to change the situation that brought this case before the court? What needs do the children have for treatment, for services, so that they can return home feeling safe, having the skills to live in their home? And again, the final purpose really is to establish an ongoing dialogue between the parties. I think I mentioned earlier, I know I've succeeded when they're talking in the hallway afterwards. And really, you're not the end-all, be-all here putting on a pre-hearing conference. You are a very early step, but a very important one. Often you are a chance to get people talking who do not wish to talk. And the longer that goes on in these cases where we have people that feel resentful on removal, or social workers that feel resentful for being called names or being accused of kidnapping children, you'll hear that often. If that resentment continues for a lengthy time, it is unlikely the parties will ever speak. And the reason that you're a key to this is that you're beginning those first steps forward. Those first steps forward to ongoing discussions about what really needs to occur for these children to be able to be reunified with their parents. process. How does a pre-hearing conference generally occur? These are general guidelines about what needs to happen and what you need to do as a facilitator in a pre-hearing conference and before. And the first thing I've noted here is to review the pleadings filed in the case. And I can't emphasize how important this is to have a productive pre-hearing conference. In my courthouse, I have access to full court. I review all of the pleadings, in particular the affidavits filed for the removal of the child. That allows me to understand things like, where are the parents? Are they in custody? Is the father's whereabouts unknown? Are the mother's whereabouts unknown? Is somebody out of state? Or do we not even know who the father is at this point? It allows me to understand how old the child is. Just understanding that perhaps this is a newborn case. Child was removed from hospital because mother and child tested positive for methamphetamines. Very common case in Billings, Montana. Or are we dealing with, as a case I had yesterday, a 17-year-old about to turn 18, and the real purpose behind the case is to find this young man a place to live, a group home where he can develop during his minority and then after he reaches the age of majority and has access to the type of services that occur and an understanding of that. Making that review, fully understanding your case, knowing what the allegations are in the case, can give you an opportunity to really sit down and look at what questions do you have. Is it explained why, two children had a problem, but there's a third child? Why is it there's a third child in this case? Why was that child removed? It allows you to look at it and develop a list of questions that you have. And then if you have those questions, the odds are very good others will. Things that you need to address. And that literally takes me about half of the time I work on a pre-hearing case. That can take an hour to 2 hours where I'm going through. If there are criminal cases pending, I'm taking a look at those cases and reviewing them. What are those allegations? Was there an old DN, child abuse neglect case, filed previously, and this is a case returning? What happened in that case? Did parents do services? What services did they do? Did they make progress? Was the child returned to both parents? These things can leave you in a room where you're in control, where you're providing the structure. Instead of sitting there kind of doing a fact-finding mission, you're able to direct the discussion to the key issues and develop those. Now, I've never walked in with my key issues and come out thinking that I was able to predict them ahead of time, but it did give me a place to start and to focus the discussion. So please do not go into pre-hearing conferences blind. Go in there understanding, reviewing the facts, knowing them down pat, ideally being the person in the room who understands this case better than anyone. Pre-hearing conferences are set prior to the initial court appearance, and we were discussing earlier how they're often the first event that occurs in a case. And what we do here in Yellowstone County, and then I think is ideal elsewhere, is we literally set it in the time period prior to the case being called. Basically here we have cases set often in the afternoon, say 2 o'clock, and the time space between 1 and 2 are left aside to allow for pre-hearing conferences to be set. This develops several important things. Parents are encouraged to be there. Parents are encouraged to participate, and they're probably the most important participant in a pre-hearing conference. They're understanding, getting to know, and have trust for the other players on the team. And then those parents go directly to the courtroom afterwards, and they have an opportunity to meet the judge, to understand what is going on in their case. So what you have is ahead of time you have an open discussion about ways we can make this case work with placement, visitation, and services, and then go directly into court shortly after for an initial court appearance. That is ideal to make sure that these cases go smoothly. And again, my next point is that parents are strongly encouraged to attend pre-hearing conferences and court appearances. Again, the reason is their understanding, their motivation to improve the case, to improve their home, is the real key to getting children home. If parents are motivated, they understand that the people at the pre-hearing conference really care about what happens in their home and happens to their children. If they sit in the court and understand that the judge truly is an objective party who's here to make sure that the laws are followed, then we have somebody who's open to being motivated, open to the idea of working as a team with the department. Social workers are also strongly encouraged to attend. And it is a similar reason from the flip side of the case, in that we need a social worker there that we can open to discussions, that's willing to hear out the parent, because maybe this is the first time the parent has been calm enough or clear-headed enough to actually have a discussion and explain how things got here, how they perceive things can improve. And if we can get social workers there to listen, explain first their thoughts, what they think needs to occur, and then listen openly to the parents about what the parents feel, believe, and understand, we have a real opportunity for ongoing, open discussions. The proceedings really need to be held in a neutral facility. I would advise against holding these in the department, not that the department really is something to be feared by the parents, and in fact it's something we're encouraging them to not feel that way. But by having a neutral site, and we often use jury rooms at the courthouse, you give the impression that there's no home ground, no home team, that everybody really has an opportunity to speak, have their opportunity to be heard. I don't think you can really do that in a non-neutral site, so I would encourage you as facilitators to make sure you find somewhere that is neutral. Your office conference rooms, a jury room at the courthouse, a conference room at the courthouse, somewhere where everybody feels they're not the home team, that they are visitors, and this is a place to be neutral and be open. Judges do not participate in pre-hearing conferences. And the reason for that is it really is a mediation process. And the legal issues are not something we're truly focused on in the case. We want people to have an opportunity without the ultimate decider in the case, the judge there, to really have a discussion where they're willing to put things out there, to put their neck out, and consider different and new ideas that people may think are not wise, are inappropriate, and get people to really have that discussion, not in front of the judge, not in front of the ultimate decider, in a comfortable environment where people can talk, in a mediation platform. Now, the ideal period that looking at this and having done this now for 14 months is, I think 45 minutes is virtually ideal for putting on a pre-hearing conference. Anything much longer and things tend to get repetitive. You might get petty. We might get off track on things that are harmful to ongoing discussions. Anything less than 30 minutes, and I've had to do them in 15, and that is a real struggle, and you do the best you can if you get that. But I think 30 really is kind of the minimum, having done these for a while now. You have to move rather briskly, but you can get it through everything in 30 if you need to, but ideally 45. And this will be one of the areas you struggle with people who do not believe in pre-hearing conferences or think that it's a waste of time. And there's going to be some give and take about how long these are, but I would struggle to make sure you're getting at least 30 minutes to get these done. Otherwise, I think you're losing a tremendous value in the pre-hearing. Now, when you start a pre-hearing conference, after you kind of introduce yourself, set the neutral setting, introduce the parties, you go through some initial questions, which aren't about placement, visitation, or services. They're designed to avoid problems later in the case and get things dealt with early. Those primarily are about whether anybody's objecting to the initial hearing or adjudication, disposition. Has paternity been established? Do we have a legal father here? Because the scenario where we don't bother with that and you're ending up with a termination hearing later on, figuring out who the father is a great problem. Is it an Indian Child Welfare Act case, ICWA? Again, I would encourage you, if you do not know what ICWA is, to do some research and make sure you understand it. Native American cases are very important, not only in Montana, but throughout the country, and understanding that law is important. getting to know whether the children are Native children, if this is an Indian Child Welfare Act case early, dealing with issues like enrollment, placement, the tribe being notified early in the case and making sure that happens avoids issues later in the case. Are there other pending cases, whether it's criminal, whether it's a domestic relations case, whether it's a previous case, and understanding what those are and how they'll play out involve the discussion that you're about to have. If there's a pending criminal case, that's going to greatly impact your pre-hearing conference. Now, the next part is then, after you get through those initial questions, you're going to focus and design and establish the beginnings of a plan for reunification. And that's where you truly get into the discussions about placement, whether it's optimal, are there options, visitation, can we improve it, can we increase it, services, treatment, are those optimal, are there other things needed, are there things we don't need to do? That becomes the key of the case. And it's after you've laid the groundwork through introduction, setting a neutral setting, making structure, going through the initial questions, and then working the plan. And then the final thing you really need to do, and you should have this in your materials from the training manual, is to put together your notes. Now, initially I tried to take notes when I was in the hearing, and that became something that didn't really work. So I put down chicken scratch, basically, make as many notes as I can, and I go back later, spend about a half hour reviewing my notes from the hearing, reviewing my notes from the pre-hearing, and then putting together notes for the parties. I send those out to the parties through their attorneys. In this county, I also send those out to the facilitator for team decision-making meetings, family group decision-making meetings, again, so that they can look at those, understand what the discussion is, what progress was made or not made, and then attempt to build on that at that point. Participants. Who should be encouraged to participate in pre-hearing conferences and why they should be encouraged to be there? Again, first and foremost, the parents. It is exceedingly difficult to put on a pre-hearing conference and make any progress without the parents being present. Whatever you need to do to encourage the attorneys to get their clients there, you need to be working on. Now, oftentimes there's only one parent there because the other parent is incarcerated or out of state. But people can be brought in from jails. People can be brought in from prison. You can get people on the telephone. Anything you can do to get a parent to actively participate early on and understand how important this case really is to their life and what they need to do to get their kids back, that can't be overemphasized. It is really their opportunity to understand what is going on. The professionals have an idea. The parents often have no idea how important this moment is. The next most important group to make sure you have there are the social workers. Ideally, you have the people who not only initiated the case through removal, but the workers who will be handling the case on an ongoing basis. Now, at this point, I believe Montana is moving toward a model of having one social worker initiating cases and following them throughout, which works perfectly into the idea of pre-hearing conferences. Because what we're doing is taking somebody that removed the children and we're putting them in a scenario where they're able to talk about why that occurred, what they hope to happen, be planful going forward, and in an open discussion with the parents instead of having different workers coming in on the case. Having them there to interact in a calm, thoughtful, and reasonable manner with the parents is the thing that can get these cases moving forward. Without them, it's very difficult to establish that trust, the real trust we've been talking about throughout these discussions today. The next thing is attorneys. Now, oftentimes attorneys find out very late that they're appointed to a case. They may have a court case in another jurisdiction across the state. Any way you can make sure that an attorney's there so that they're part of this discussion. Because frankly, they're structuring their party's position. They're looking at it from a legal standpoint. They're directing it from that standpoint so that their parties, a parent, the state, guardian ad litem, can understand the legalities of what's going on and structure it in that manner. You, as the facilitator, really do not have that opportunity to do so. Now, in Yellowstone County, I believe we have a different structure for guardians ad litem than you may have in your jurisdiction. If I understand correctly, what we have is guardian ad litems who are also attorneys representing the best interest of the child. I understand in other jurisdictions, guardian ad litems are sometimes from the CASA office or other offices, and there may very well be an attorney separately appointed to represent the child. Now, whatever your jurisdiction, understanding the position of the guardian ad litem, what they're promoting in the case, can be highly important. And what will happen in pre-hearing conferences occasionally, and I will make this mistake myself, is we'll get focused on the parents. What do the parents need to do? What are the parents moving forward? And we sometimes forget the children, which is the ultimate irony. The case is about the child. They are the named party to the case. Guardian ad litems, I have found, when they actively participate, can steer the discussion back to that important point, which is the changes need to be made so the child can be safe. Now, those changes may have to be made by a parent. It may have to be made about the home. It may be a medical issue. But in the end, the focus is on making this child safe in a healthy environment. And sometimes, when you forget as a facilitator, a guardian ad litem can really direct it back to that moment. An attorney for the child, the same, direct the topic back to what about the child. CASAs, court-appointed special advocates. Again, in some jurisdictions, I understand CASAs are taking on more of a role of a guardian ad litem. In our county, the CASAs truly are reporting to the court on the best interest of the child. Now, CASAs are traditionally not appointed at the point where you're first appearing in court. This is the first court appearance. Sometimes they're appointed later on. I have been encouraging the supervisors from our county to appear, and sometimes they appear with a prospective CASA, somebody there to take a look at the case. And they often look at more complicated cases and say, could we play a real role in this? Having them there can change the perspective of things. In explaining for once to the parents, what is a CASA? They don't often get that explanation unless they talk to their lawyer. And the parent can simply say, wait a minute, what is a CASA? What do you do? And the CASA can sit there and get a feel from the start of a case of what this case is about. Where is this case going? And become a part of the team making the plans. Often we have people who are retired teachers, active members of the community filling that role. They have knowledge that we as lawyers sometimes forget. We're focused on the law. They're often focused on things that a simple, intelligent, reasonable person might focus on, and we just simply do not see because we're focused on the law. If you can get that type of person, a real true CASA involved in a case early on, it can make a big difference in how this case looks moving forward. Now, family members and friends, there are different thoughts on this, and I do ask because it is a mediation setting, whether people are okay with having friends or family of the parents, children, in that room, as they're not truly a party to the case. Most times people have no problem with having these individuals there. They are support for parents. They have a perspective from the parents. And I'll often try to feel these people out before I let them into a pre-hearing conference. I might chat with them for a few minutes ahead of time to find out if they're going to be a problem. Because there are sometimes people there who just want to put some more fuel on the fire. And I encourage those individuals that this is not a setting for them to be in. But there are other individuals who are really there to support. And they've been doing it for years. It's a rare occasion that you have a set of parents in front of you who've had their child removed, that they haven't had ongoing problems for much of their life often. And that the individuals, these family and friends, they have been working with these parents for years. They understand the intricacies of the problem. What triggers the parent to go back to using drugs? They're able to bring that aspect, and they're often able to bring an honesty to the discussions If a parent tries to get off and tell a story which may or may not be true, family and friends sitting there can call them on the truth and say, well, that's not really how things went, and bring it back to an honest discussion. And just having a support network, not being alone, sitting there alone working as, say, a single mother or a single father with no support, working with the state, you're asked to do 5 different treatment plans, hold a job, get a house. Just having individuals for them to talk to support them and care about them outside of our setting when we're not there can make all the difference in the world. Treatment providers. You'll sometimes be in an occasion where a parent has, say, relapsed or has had an ongoing therapist, or the child has had an ongoing therapist. Just yesterday I held a pre-hearing where the therapist counselor for the child was present, not sharing, HIPAA violation type of discussions, but listening to the discussion, offering where they were in their meeting, how long things were going to take. And they're going to be rather vague about that, but it gives you a chance to understand what needs to be done, what's been going on. Okay, has this parent been in treatment on and off for years and this is one relapse? Or is this somebody who has avoided treatment for years and now is just now thinking about having treatment? How you talk to that person and how others talk to that person about getting in treatment are very different in those scenarios. And understanding that a child, say, has had therapy or counseling on an ongoing basis, and this is a long-term problem, gives you some perspective on how long this might really take to reunify this family, what lost trust there has been between child and parent. Getting those people there can be a big help for everybody else understanding, and alternatively, it can give that therapist or counselor or treatment provider a real understanding of the big picture, what's really going on, and gives them a chance to understand, this is more than me working on drugs with this parent. This is more than me working on individual counseling. This is a big picture, and what I'm doing needs to fit in that big picture. Now, there's a controversial one here, having children present for pre-hearing conferences. In other jurisdictions I've been in, children were highly encouraged to be involved in the process, to being in court. In Yellowstone County, I have found that is highly discouraged, that they are worried about the children. And it's something you have to deal with on a case-by-case basis. Obviously, a young child cannot be in the room while we have truly adult conversations about drugs or violence or mental health. But somebody in their mid to late teens who has lived this problem, has lived these issues, you're not really hiding anything from them by not having them in the room when they are the real party to the case. And oftentimes they have a perspective that nobody else has about their own safety. This is their life. This is their case. And you should consider giving them a chance to participate actively in their case and the planning for what needs to be done. Because kids are going to say things that are going to be brutally honest, sometimes rude, but they're going to be direct to the point about what a parent needs to be working on. The final issue, and again, somewhat controversial, would be security or law enforcement. You're going to have occasions where you're reading the affidavit and there's a degree of violence that's somewhat shocking. People are going to tell you that it's not safe to have a pre-hearing conference. And there may be occasions that happens. I have not had it happen, but there is certainly a point to be thought about. Is this something that you can really safely do? And that may depend on the security in your courthouse. But I would encourage you to be thoughtful before you use security not to have a pre-hearing conference. And just talk to the parties, talk to the attorneys, and find out if they really think it's a risk or this is just a subject that they're putting out there to avoid putting on a pre-hearing conference. But security is an issue, can be an issue, and you need to be thoughtful of it in all of these cases. Introductions, setting the ground rules for pre-hearing conferences and introducing the participants. What I'm talking about here is what occurs when you really do start the pre-hearing conference. You've done your research, you've created your notes, You have questions you have ideas about how you want this pre-hearing conference to go and what structure you want to apply to it. But you're sitting down at a table with 8 to 12 other people. There are parents there who have little trust for the government. And you need to do some introductions, set some groundwork so people understand what is going on, and that this is really a neutral situation where they can talk about the case. This can be one of the most difficult parts of a pre-hearing conference. It's part of you selling yourself, whether you use humor or you use a paternalism or whatever it is that you use to make people feel comfortable. You need to rely on those things that you use in conversations in real life, conversations you've had with your clients who may be difficult in your life, and use those same things to create an environment in a few minutes where people are willing to talk about the case. Now, when I introduce myself, the first thing I do is point out that I am a neutral and objective facilitator employed by the court. I literally point around the room to everybody in a circle and say, I don't work for any of these people. I don't work for your lawyer. I certainly don't work for the department. I work for the judge in the case. I am neutral and objective, and that is the first thing out of my mouth when I have a pre-hearing conference. I ask if they have questions about my role, and if they do, I address them and make sure that we have a clear understanding that I am neutral. I then point out that the clients may have legal questions. As I said earlier, often attorneys are appointed very late on these cases through no fault of their own or anyone else, frankly. And they get a case and they may never have had an opportunity to call the client. They may not have had your opportunity to review the file. And they are there for the first time listening to the case. These attorneys and the clients need to be directed that if there are legal questions, for instance, if you want to know about your rights, you want to know what's going to happen in court, should I say something? You need to talk to your lawyer. And if we have to take a break, if you say I need to talk to my lawyer and take a break, we'll take a couple-minute break if you need to do so and just chat with your lawyer. And at the beginning, if they haven't chatted with the lawyer before we start the pre-hearing, I often say, do you guys need a few minutes to talk? Because it is much more valuable to the discussion to let them talk ahead of time, figure out what areas they're going to address and not address, than to try to take in a break in the middle or have a client that's reluctant to talk because they haven't had a chance to speak to their attorney. Now there are the ASFA timelines, the Adoption and Safe Family Act. And again, this is one of those laws, a federal law, that I encourage you to take a look at if you don't know thoroughly. There's a lot of sources online for doing so. But timeline importance and directing that to the attorney. I will often point out that we do have timelines, that in essence, parents have basically a year, a 22-month period to make the improvements that need to occur. Now, all of us who know the Adoption and Safe Family Act know that there are exceptions if a child's placed with a relative or placed back with a parent, or if there's good cause to continue things. But parents understanding that really there is a time period here, and it is a short one, to get things done, to make the improvements that are needed, is something I think that you need to say up front and then encourage them, because you're making a very brief statement, to encourage them to talk to their lawyer in detail, because it is not your job as the facilitator to do so, in detail about what the timelines are. When are we going to be back in court? What's a review hearing? What's a permanency hearing? What are the possibilities of termination, and when would that occur? Can I get my children back in 2 months just because our next court date's 6 months out? Encourage those discussions and do it in a way that the client is likely to talk to their attorney about what the timelines are and what they need to do, because one of the reasons we need to get things going quickly is because there's a short amount of time to make the changes needed to get children home. I talk to them about the initial court appearance. Sometimes people are confused whether I am the facilitator and the judge. Is this the court appearance? Do I go to court later today? I'll explain that up front and say that this is a pre-hearing conference. We're going to sit here and we're going to discuss certain issues like placement and services and visitation. After we're done today, I'm taking notes. I'm going to send those notes out to your lawyer, but you're going to go into court with your attorney for an initial court appearance in Yellowstone County, a show cause hearing. And you're going to go in there and appear in front of the judge with your lawyer in a more formal setting, and that will occur at, say, 2:15 in the afternoon. Let's say I'm doing a 1:30 pre-hearing conference. Because what we've had happen is people literally will think they had their court appearance and disappear. That's what's part of my learning process here, is to make it clear that this is not the court appearance, this is a pre-hearing conference, and that they will need to appear in court. And again, I'm encouraging them to appear at both. The other reason would be to sit with a judge, truly get a feel that this is a neutral setting and understand that in the courtroom. Now, the next thing I do is introduce the people around the room. I set out what it is that I do, what my job is. And then I go around the room in either a clockwise or counterclockwise fashion and have people introduce themselves. What is their role? It could be as simple as I'm Joe Smith, I'm attorney for father. It could be I'm Marie, and I am the mother in the case. Or it could be something more complicated, like somebody saying they're a guardian ad litem, and explaining exactly what the role of a guardian ad litem is. It's not going to be something commonly understood. Or if there's a county attorney there, why is there somebody from the prosecutor's office sitting here? Or in the case of a CASA, what is a court-appointed special advocate? What is their role? And explaining that in some detail so the parents, who are often, this is early, and they're unlikely to be asking a lot of questions. So if you could encourage your people to just lay out what a CASA is, what a guardian ad litem is, what role the county attorney plays in these, it can make a big difference in people feeling the trust. And knowing that this is not some stranger looking over their shoulder, but it's somebody here to promote the best interest of the child. Or someone here who is an attorney who represents the social worker, the state. That simple understanding can involve trust because there's a lack of the unknown, a lack of secrecy. Transparency is there and that everybody knows what everybody is doing. Now, I have an attendance sheet, and you probably have one of those in your materials. I hope you do. And I explain. I hold it up and say, this is the attendance sheet. I'm going to ask you to print your name, sign your name, and put down your role. It could be mom. It could be dad. It could be grandma. Just so that I understand when I'm taking my notes exactly who is here. I'm not going back and trying to stretch my memory. Who is part of that discussion and who are making these statements or just listening. I explain that this is not like a contract. You're not agreeing that the things in my notes are things that you're going to do. But that our hope today is that we actually reach some agreements on the key issues of placement, visitation, and services. But that this is not a contract, that you're not signing that I will do the following things. Now, the next part is I attempt to seek to focus the discussion on the best interests of the child. I attempt to talk to everybody and say what we're really here to do is to figure out what is best for these children, for this child, and hope that everybody does focus upon that. As I discussed earlier, sometimes a guardian ad litem needs to steer it back. But in the end, what we're looking at is what is best for this child? What can we do to make a plan for the best interest of the children? I then ask parties to be courteous and respectful and listen to everyone. This is that part where we're talking about giving everybody a chance to speak and be heard, that others will listen, encouraging everyone to feel comfortable to speak, and encouraging everyone to actually listen and consider the perspective of other individuals in the room. Again, this is part of the structure and a vital part of your job. And I ask that one person be speaking at a time and allow them an opportunity to finish the thought they have at that point. That doesn't mean that you're allowing a person to ramble and ramble and ramble. And sometimes your job as a facilitator might be to interrupt when a person tries to make multiple points or rambling points. So what you're encouraging people to do is to take a time to give out one thought, to have everybody listen to that one thought, consider it, respond in a respectful manner, one person speaking at a time. The discussions are confidential and are not to be discussed with persons not involved with this case. And this can be an issue when you have friends and family there, and you may need to very well remind people, if that's the scenario, that what we're having is a discussion here. This is a juvenile case. These cases are sealed. These things are not to be discussed outside the parties. Now, you're going to have situations where a treatment provider is discussing something in a vague fashion and a parent is there. You may have a situation where it's important for either you or the treatment provider to say, this is not to break the trust between the therapist and child. This is here so that you understand what we're working on, what point we are at. And these things are not to be discussed with friends at school or friends out on the street. This is a confidential situation and needs to be kept that way. The notes I provide that I've drafted from the hearing and then I redraft in an organized fashion afterwards go to the attorneys. The attorneys can disperse them to the parties. They do not go to the court. And again, this is part of the fact that it is a mediation process. It is a pre-hearing process. There are things being discussed here that parties may not want to go to the court or may not even be admissible in a court hearing. So they go to the parties, again, with the idea of getting ongoing discussions between those parties to move the case forward so that when you do appear in front of the judge, you're able to report progress and the case moving forward. Key issues for pre-hearing conferences. What are the key issues to be discussed in a pre-hearing conference? Again, we're just after the introductory portion of the discussions with people. At this point, we're telling them, what is it we're going to be discussing today? What are the areas? What are the key things we need to discuss? And those things are listed out on the slide you have before you. The first one is the placement issue. Where are the children placed? And are there better options for placement? You want the parents in particular to know that just because the child is placed somewhere at this point doesn't mean we're not going to be discussing other options that may be better. In particular, the things you're looking at is, can the children be placed with a relative, with a friend, a daycare provider, somebody who has an ongoing relationship with this child? Or even, in some cases, going so far as, can the child be placed with a parent right now? The next thing you're looking at is, what is the plan for visitation now, and can the plan be improved and or increased? Now, you want everybody to know what the visitation is now, and often the visitation at time of a pre-hearing conference is nothing has occurred yet. So you have a real role in figuring out, we need to get things started. You might have a young child, they haven't seen their parent in 3 weeks. There are going to be finger pointing going on. The state may be saying, well, parent didn't return my call, parent didn't show up for visitation. And the parents may be saying, you didn't call me, you said it was going to happen on Wednesday. This becomes a real finger pointing situation and something that you have to be careful of and say, no. Where are visitations now? And where are they going to be? And if you're at the point where you're starting up visitations, you need to establish a plan for doing that. How is this going to happen? There are occasions when a parent can't visit. They committed an act of sexual assault, abuse against the child. We're not in a scenario where visitations are happening. But in most cases, visitation should be occurring, if only so that the children can see that their parents are okay, are working on the case, and they're making progress. And we can often plan. Just like we were looking at relatives or other providers, we can be planful and say, well, this same relative who might be a placement option, could they help with visitation? Can they be a supervisor for visitation? You need, particularly in the case of visitation, to think outside the box. And what services are needed for the family to begin building a plan for reunification in a safe and healthy home? This is the treatment question. What needs to be worked on? You need to find out from the caseworker what it is that are the problems in the case and what they are moving forward. At this point in our pre-hearing conference, I'm laying those things out for particularly the parents. The other professionals know where we're going at this point. They don't. And say to them, these are the topics we're going to talk about today. And this is where we're going. I lay out our goals. I say, frankly, that we're trying to reach as many agreements as possible regarding these key issues. That doesn't mean we will, but it's encouraging people to find areas of agreement. We can place with Aunt Sally. The state has heard about Aunt Sally. They haven't looked at her. What does Aunt Sally need to do? She needs to come into the department, get fingerprinted, have a background check. People take a look at her home. Everybody agrees that looking at Aunt Sally is a good idea. That in and of itself makes the whole pre-hearing worthwhile. If that's all you ever get is a look and an encouragement to have a relative placement and an agreement that it's a good idea to look, you have done something that day that is important. To make a plan going forward concerning the key areas. So when we figure out what they are, what our key area, where we are with placement, where we would like to go with that. Where are we with visitation? Where would we like to go with that? As far as services go, where we would like to go that? Where should we begin? What should we prioritize? Let people know right up front before we start discussing these issues that these are the things that we're going to talk about. So the people in the room know who's in the room, they know what their roles are, and they know what we're going to talk about today. And the last thing is a very important one. When we cannot agree, be respectful of each other's position. Explain our own position in a way that is reasonable and understandable. And again, this is the opportunity to speak, be heard, and listen. Emphasizing that before I really begin is the most important thing that we do. In that people understand that we're going to have a discussion. They're going to hear things they disagree with. It's okay to say, I don't agree, or I think you're wrong. But then also to put out there what you believe to be the correct solution, what needs to go forward, and saying it in a way that's not offensive, rude, but saying it in a way that is reasonable and understandable to the other individuals in the room. And that is the groundwork we lay before beginning the real discussions. Initial questions. What do we need to know before discussing the key issues? Now, we've discussed this briefly before. I'm going to go into the actual questions that are being asked by the facilitator at the beginning of the case to lay that groundwork, to make sure we have things like ICWA, paternity, pending cases established. The first thing I ask is, does anyone plan to contest the initial hearing today? Is anyone contesting emergency protective services? Now, what you may hear is, I haven't had time to talk to my client. I'd like to set, in our case, show cause over to the adjudication date. That's fine. But if you're hearing that we are genuinely contesting and that we plan to contest this case and we don't believe the state has a case even initially, it's time to see if you can explore that and get that out there. Now, in other jurisdictions, this is actually the key moment of any case. You're focusing on jurisdiction. You're focusing on the court, the legal issues. In Montana, we tend to focus on bigger issues. But if you find at that moment there's a contested hearing, this is a chance to ask the attorney, well, do you mind if I ask what it is that you're contesting? Well, we think the child is safe. Well, what do you mean by you think the child is safe? I mean, how can the state feel comfortable in, say, dismissing the case as opposed to having a contested hearing? What is it? It's a real opportunity if you hear something's contested, and you may know, just doing your background research, that this is not the strongest case in the world, that the parents may have a legitimate claim. You could sit there and discuss other possibilities. Do we want to just set this out? Do we want to work on things between now and the adjudication date? Do we want to establish temporary investigative authority as opposed to having temporary legal custody? What options are out there in a case that may not be particularly strong against the parent, but the state obviously has reasons for concern? And if you hit that with the first question, it is a good moment in time to explore these things, see if people are willing to discuss it, and get it out there and have a discussion. Because you may be able to resolve the whole thing starting with that one question. Now, there are cases where essentially the parents have made a real mess, that it is obvious to anyone that the children need to be removed, including themselves and their attorneys. If you find they're not objecting to the initial hearing or the show cause hearing, and it seems to be the type of case that the parents are willing to admit, yes, we made a mistake, I really want to do whatever I have to do to get my kids back, and it's something that takes experience to learn, you might want to sit back and really think, is it a moment in time where I could ask, do we really need to keep the adjudication and disposition dates on the calendar? I mean, do we really need to hold another hearing where we're discussing whether there should be jurisdiction? Or can we stipulate to that at this moment in time and agree that temporary legal custody is good? Allowing the parties to focus on the big issues, focusing on what needs to be done for the children to be safely returned, as opposed to having another court date for no reason. And I will say this has occurred, I don't know, less than 10% of the time, but enough that court dates are being removed from a busy docket, where we're just simply moving on and saying, yeah, there's jurisdiction here, and yes, disposition needs to be temporary legal custody, and we're moving forward. And you may be in a point where you can ask that question, most times not. It's something to feel out. If somebody's offended, say, I was just asking a question. The next thing, again, is the paternity issue. Has paternity been legally established? And again, that could be just a huge issue later on. And getting the parties to focus early. There might have been a couple of questions of the mother. Who's the dad? I don't know. Where is he? I don't know. And what you don't want to occur in your cases is that it drags on and nobody looks back at this paternity. So we get to be a year and a half out, they're seeking to terminate parental rights, and we don't have a legal father. It's exceedingly important to find out who that father is, get in contact with that father. Is this an Indian Child Welfare Act case, an ICWA case? And this affects the legal standards. In an ICWA case, the standards are higher. You're not proving whether reasonable efforts are being made. You're having to prove whether active efforts are made. In the case of termination, the proof is up as high as proof beyond a reasonable doubt. They are higher standards. There are things that are important to the children to be enrolled. If they're a tribal member, are they enrolled in that tribe? What needs to be done to get a child enrolled in their tribe so that they have all of their rights as a tribal member? And how do we get the tribe involved if they're a tribe? What efforts are being made actively, active efforts, to contact the tribe, to get the tribe involved in the case for all of the good purposes behind ICWA? Are there pending related cases? And frankly, this can go beyond pending cases. Trying to find out, is there a domestic relations case? Maybe parties are working on something already, something occurred during the domestic relation. It's questionable whether the allegations are true, because people may have motivations to lie with regard to custody. It is a good thing to know if people are in a situation where there are reasons to be motivated to be untruthful or truthful. Is there a criminal case? You don't want to put an attorney in a position where their client is talking about the issues of a pending related case. That is criminal. These people have the rights to remain silent, the right to consult with the attorney, and you need to be respectful of those rights so the person isn't talking, if you can help it, about what it was that brought the case. If there was an act of domestic violence, for instance, or drugs, we're not talking about that. We're talking about placement, visitation, and services, and be respectful of those pending criminal cases. And sometimes there are cases previous, and just understanding what that old case was. Hopefully you have done your research and have a good idea, but understanding what the parents did, maybe they did everything perfectly and you're just dealing with a relapse. And we need to get a parent back on track, that they have the skills, they've had the treatment. And what needs to be done here is to get that person back on track, having an understanding of that, allows you to be planful. What services and treatments you're going to be talking about? Was there a team decision meeting? And again, in our jurisdiction, they try to have team decision meetings within 72 hours of removal. They're going to be talking at those meetings about a lot of the same issues that we talk about. Did it happen? Who was there? What was talked about? You may be not starting a case like we usually do with one of these pre-hearing conferences, but you may be the second person in line looking to build on what has occurred previously. Parties may have agreed, we're going to have a chemical dependency evaluation. That's scheduled this Friday. I'm going to start anger management. I have a meeting for that next week. And having an understanding where things are and what has been previously discussed allows you to say, here's our starting place. We're not going backwards. Let's move forward from that discussion. And finally, I think it's important to discuss when and where the next court date is. Now, you've already told them that we're going to be in court in 45 minutes or whatever time it is. But just putting it out there as repetitively as possible when the parents need to be back in court. So everybody understands that on April 15th at 2:30, you will be before Judge Smith in courtroom 1705. But just putting it out there as many times as you can, as you know, as lawyers, it's important to be repetitive with our clients so they remember things. Just putting it out there and knowing when that date is. Are there going to be family group decision-making meetings? These are the ones held by professionals, and in our case, they're held at the offices of the Department of Public Health and Human Services by facilitators. And again, I share my notes with them, so they have those in place. Has that been set up? If it hasn't, encourage the department to get one set so these conversations occur. And if it has been set, again, repeat when the date is, where it's going to be held, and what time it is going to be held. Children's update. How are the children doing, and what needs do they have? At this point in a pre-hearing conference, we're really getting into the meat of the matter. We've done the initial questions, we've done the introductions, we've laid the groundwork, we've established a neutral and objective situation. And now I really just throw out there to the parties. I don't look at anyone in particular and say, how are the children doing? And sometimes it's important to note who talks, who speaks up at that moment. There's a lot of looking around, who's he talking to? And to find out the dynamics between these people. Who speaks up? Do others support that person's position? Are they argumentative with each other? And get a real feel at that moment in time. Because it's a tough question. Kids have been removed. They're with somebody else. You're a parent, and somebody's going to say, the kids are doing great. That's a tough moment for the parent to hear that. Or alternatively, to hear that they're doing terribly and having all types of trouble since removal. Another tough moment. But again, to listen, encourage people to speak. If the caseworker or social worker speaks up and you listen to them, turn to the parent. Have you had a chance to see your kids? Have you been talking to them? How do you think they're doing? Because again, this is really about the children. This is their case. Find out, is there a foster parent in the room? Talk to them. Are there treatment providers in the room? Talk to them. Are there friends and family? Talk to them. Because understanding where the kids are at this moment in time really steers our discussions about what needs to be done. Where are they placed? Should they be placed elsewhere? But just knowing what is happening at that moment can be truly important, and you can find out the dynamics of this situation. Who has strength? Who argues? Who doesn't agree? And it allows you a moment to really assess who these people are in the room and where they stand. You want to find out, have there been any assessments of the children? Do people think the child has a hearing issue? Is there a hearing test set up next week? Is there an ECI set up at this point? Where are we and what is being assessed? What do people think need to be assessed? And what are the results? I mean, why is somebody saying the child needs a hearing test? Find out, well, the foster parent told me that when they talk to the child doesn't turn or something. Ask the parents, have you experienced that? Is that something you experience, or is this something different than in the past? Because in the end, whether everybody in the room likes it or not, the parents do know more about these children than the other people in the room as a general rule. Do we need additional assessments? Are additional assessments needed? Okay, we've had the hearing test, but there's an issue at school. The child had an independent education program last year, an IEP. They're entering a new school. Do we need to have an assessment there? How is that going to work? Find out if people think there are other things that need to be worked on. And if you're hearing things in the discussion that you might suggest, well, weren't we just talking about vision issues? Shouldn't that be done? Has there been a dental visit? Are there dental issues? Does that need to be set up? But this is an occasion where you might put yourself into the discussion and suggest things that need to occur as far as assessments. Again, you're the facilitator. You can't make it happen, but you can certainly encourage that appropriate assessments are being done. Are there special needs for the child? This could be medical, dental, emotional, mental health. There's a wide array of things. Throw it out there. Ask again. Does the child have special needs? Oftentimes people just kind of look around and say, no, this child appears healthy and safe. Other times you're going to hear the effect of the abuse and neglect. Other times children are going to have issues all of their own that need to be worked on. We can't ignore things just because it isn't related to the abuse and neglect. Those things have to be dealt with. And we need to discuss them openly and get it out there early. How are the children doing in school? A lot of times these kids have struggled. They're, by definition, in a home where there may be abuse or neglect. And they've struggled in school. There's not somebody there sometimes to help them with homework, or to make sure they wake up on time and get on the bus, or they have an appropriate coat to go to school in the cold weather. They don't have that support network. Or they were doing fine in school and now they've had to change schools because of the placement. How is that happening? We talked about the IEP. How do we make sure that independent education program transfers over to the new school? That these kids are getting the needs they are. So find out how they're doing in school. It's a independent reflection of how the child is doing from professionals in a school environment. It gives you a look into something you're not going to see from the parents or social worker. And focus the parents and social worker on that. Are there any immediate concerns about the children? I've learned the hard way that that's an important question to ask. To just simply say, do you have any immediate concerns? You may find out they don't trust the foster parent and that they have a reason not to trust the foster parent, or that their child has told them something that is hugely concerning. Put it out there. Give people a chance to answer that question. Because if it's immediate, we need to address it now, and we need to make it the focus of this pre-hearing conference. Placement of the children. What are the best placement options for the children? This is where we get into the real meat, the three subjects that we're here to discuss, which are placement, visitation, and services. I have found from my experience that starting with placement is the best option. It often flows into discussions about visitation and services, and I found it the best place to start. Now, I ask, where are the children currently placed? It is a rare occasion where everybody in the room actually knows the answer to that question, and can be a huge moment in the importance of the case. Where are these kids? Now, there are cases where there are reasons not to indicate, but in most cases I found they're willing to say they're in a regular licensed foster care with the Joneses. Guardian ad litem goes, oh yeah, I've had kids there, they're good people. Or they're placed with Aunt Sally or Aunt Nancy or Uncle Bob. And we find out who they are. But just getting out there, where are the kids right now? Skipping it doesn't lead to a lot of productive discussions. What type of placement is it? Okay, these are the Joneses. Who are the Joneses? It turns out the guardian ad litem thinks the Joneses are a great placement because it turns out that Ms. Jones is a nurse and that this child has high needs. And they have spent a great deal of years bringing kids through their home who have special needs, who've had difficulties, and many of those children have been returned. A parent knowing something like that their child has needs, and that the case is able to go forward with people that have had children in the home that have been returned, and that those people are able to deal with these difficulties while the children are away, can make a huge difference in how a parent feels about a foster parent. If it's Uncle Bob or Aunt Sally, why did they step forward? What is it about them? Have kids stayed there multiple times in the past? You'll find that in here. When the parents had trouble, the government didn't need to get involved. Aunt Sally has watched these kids on and off for 10 years of their lives. And you may find out that, how essential really is the state involvement if there are family members who are able to step forward. Is this a situation where we could talk guardianship, for instance? Instead of Aunt Sally having an informal relationship with the kids, that everyone agrees it'd be a good idea that she'd be the guardian of the children. Not that we're terminating parental rights, not that the children won't see their parents frequently, but that Aunt Sally has legal rights. These are things you can talk about when you find out what type of placement you're dealing with. Have the parents met the foster parents? Again, a lot of times visits haven't started or they're just starting, and the parents have no idea who these people are. Talk about, can they have a chance to meet with them? Is there an opportunity to share things? To sit down with the foster parent as the parent and say, my son had bedwetting issues. He's not going to talk to you about it. He's embarrassed. These are the things we tried. Or vice versa. A child is finally potty trained in a foster home. And the foster parent relating that. Or learning, hard things like your child took their first steps or spoke their first word and you were not there as a parent. At least having the opportunity to share those, find out who the person is, sit in a room with them and talk and get to know this person can alleviate a lot of fears about who the foster parents are and what they're here for, which is really to make sure kids are safe. A key, and this is a real important thing in all of our cases, if the kids are not placed with a relative or in a kinship type placement, it is exceedingly important in pre-hearing conferences to find out if there are people out there. Parents are sometimes told, and you'll hear it, that don't give up the name of your mother as a placement. If she gets the kid, you'll never get your child back. And they've been fed a lot of misinformation. It's a real opportunity to get kids in a familiar environment. They're with a relative, they're with grandma, say, and they know grandma. And it is conducive to continuing that parental relationship. They know they're not with their parent, but they're close to their parent. And that this person cares about their parent. Knowing that the person they're placed with cares and knows their parent can be huge in a case. In the event that things do not go well, and we're reaching a point of filing for parental rights termination or permanent legal custody, you have a ready-made way to explore the idea of guardianship, as I said. Or, if it's an adoption situation, at least it's one within the family where the parent may play a role. And the child will have an idea of where their parents are, to know whether they're safe or not, to know what's happening in their life, instead of that always being a question. Whatever happened to my mother and father? To at least know through their new family what happened, and hopefully that they did make progress and are playing some role down the road. Or alternatively, it can ease the transition. If a child's transitioning home and you're looking at having overnight visits, community visits, or things of that nature, and children that are grandmas, and mom and dad or mom or dad live a few blocks away, the ability to transition those kids home in a smooth way, where they're not going from a group of people that don't know each other, can be a much smoother process. So you need to really explore that. And particularly in the case of the Indian Child Welfare Act, where there's laid out priorities for placement, number one being relative placements, and that active efforts need to be made. In an Indian Child Welfare Act, you need to spend a considerable amount of time on looking at relative placements, because active efforts in doing so are required. Is there a non-offending or non-custodial parent? Montana law provides that in disposition, and you've probably heard of the SS case, that a parent who is not accused of doing anything wrong, not being unfit, and non-custodial, can have the child placed with them as part of a disposition. If you're in a situation like that, you need to know, because this case may be quite brief. You may be reaching a point where in disposition, a month or two down the road, the case is being dismissed and child placed with a non-offending, non-custodial parent. You need to have a discussion at that point about whether that is an option. Does that parent want placement? Are they truly safe? Just because we didn't see something early on, is it really a safe parent? And alternatively, what is the offending parent, for lack of a better word, to do? How are they going to seek services so that when this case is over, down the road, that there are two safe parents, not that the child was just returned to one and the offending parent was left on their own to figure out how to work their safety issues, but there's a plan. Now, if the case is dismissed, you're still going to be able to get referrals to a mental health center, or you're still going to be able to get treatment for chemical dependency, and how that's going to look, so that even though we're out of the case, that the issues of two safe parents are being addressed and being planned for. And the last one is, can the children go home? I mean, you took a look at the case. You've reviewed the facts. You've been listening to their issues. You've had introductions. And you may be at a point where you're hearing, well, really, I understand where maybe the state needs to be investigating, that the state maybe needs to be looking over this case, but do the children really need to be out of the home? And this isn't a question you ask in every case. And again, people may be offended when you ask it. What are you talking about? And just say, I'm just asking, do the children need to be out of the home? If they say absolutely, well, what is it that you think makes it so that the children can't go home now? Well, we can't feel safe. They have these issues. Well, what would make you feel safe? What could the parents do as far as services or coming forward? What could they do to change that thought? And it can lead into that services discussion and treatment discussion. Visitation. What are the visitation options, and can those options be improved or increased? So we've talked about placement, and I'll be perfectly frank with you. There are times where you go from placement to visitation, and you go from visitation to services and back, but try to keep it as compartmentalized as possible. But that doesn't mean you can't have issues cross over. For instance, if you have a relative that could be a placement option, but they could also be there to increase visitation and supervise them. It's certainly okay to go back and forth, but the more compartmentalized, the more likely you are to have reasonable discussions. So again, what's the current visitation plan? Throw it out there. I haven't had a visit. My first one was last Tuesday. 3 were canceled. A caseworker coming back at you. They don't return my calls. They didn't show up. All right. You got some work ahead of you here. You need to start saying, well, these need to occur. We all know that. It's best for the kids. It's best for the case. So let's throw all that aside and start talking about moving forward. Forget the last 3 weeks. And look them in the eye and get them to agree that we're moving forward. You might also be in a situation where a lot of these discussions have occurred already. Nothing makes me happier as a facilitator to hear what they're doing and how great it is, and I'm just taking notes about this plan. In between those extremes are usually where you're going to lie. And finding out what that plan is now is always key to finding out how to move forward to increase and improve those visits. Can that visitation plan be improved? Well, the answer has to be yes, unless the kids are already home. Okay, how do we improve it? What ideas are out there? We're thinking outside the box. Now, what is it that would make them better? Well, the parent sat on the couch and didn't interact with the kids at the visit, or the parent brought an inappropriate snack to the visit. Let's talk about that. Let's talk about the importance of that and how that is a signal to the children that when their parents show up, that it is a structured visit. The parents are the parents, and that things are going appropriately. And when questions are asked by the kids, that the parents are saying, these are adult subjects, and I'm working on them. No promises, no guarantees. Are there options for referrals which would increase and or improve visitation? And this area would be called, I think, therapeutic visitation, or offshoots of that. And the idea would be, there's been a problem. Would it be good for the children to go to this therapist with the parent? We're having observed visits. A professional is commenting on them. And given an opportunity to not only have a visit, but simultaneously be gaining counseling and therapy. Hearing feedback and saying, this is how I think it's going, why did that occur, and having a conversation. So simultaneously we're having two benefits. One, the children are getting to see their parents and not vice versa. And two, that their parents are getting feedback and understanding about how these interactions appear and how they might improve. Are there relative or kinship options for increasing visitation? Again, relatives, family, kin. How can we get them involved? And it could be as much as we have somebody, she's an accountant, and she's the mother's sister, and she's just got kids of her own, and can't she sit in? Can't she go with mom to the park? How would that be unsafe? How does she report back if she sees something inappropriate? How do we establish boundaries for the sister where she has to sometimes report things about her own sister that are not positive? Are community visitations an option? And a community visitation, at least as I talk about it, and you may have different terms, is when a visit happens, for instance, out in the park, McDonald's, a movie, Chuck E. Cheese. But where the parents are going out, they're having an opportunity to meet with their children, to take them to the park for an hour. They've had these kids for 10 years, and before we came in, is it really a big danger for mom and dad to take these kids to the park for an hour? Well, yeah. If they said, I'm going to flee the state as soon as I get my kid, or they're a violent person that can't be trusted for 10 minutes. But most people can probably take their kids to the park for an hour and be trusted to return. And again, talking about trust, I brought it up multiple times today. This is a moment to establish greater trust. A parent can show that they could have a community visit, go to the park, go to McDonald's. And the state can learn the trust and say, you know what, they did that. They came back. The kids looked great. They told me they had a good time. They told me about how they were on the swings and things went well and mom was nice and appropriate. And that can establish greater trust down the road. But can we have that now? It's a question I address. And again, can the children be transitioned home in the visitation conversation? Can we start to, is it a point in time already where we can have overnight visits? Is it, maybe they can't return home now, but let's see about having Friday night. This is not that serious a case. We have serious concerns, but can the kids spend the night over? Now, you're going to get resistance. People are going to say, are you kidding me? We have a way of doing things. We ramp it up at this pace, but you may already be there. Not every case is the same. You might already be in a place where something happened and you can start to have a Friday night or something of that nature and talk about a move home. And for instance, the example used earlier of somebody who had done treatment, had been through a relapse, but is now back clean and sober, working the program. Do we need to really wait 6-9 months for the start transitioning? Or we are in that place now while parent works on the relapse or the issue? Find that out. Services and treatment. What services and treatment are needed by family members to create a safe and healthy environment for the children to be returned home? Now, this is the real purpose behind DN cases, behind the involvement of the department, assuming people agree that there are issues that need to be resolved, is what needs to be worked on. Now, in Montana, treatment plans, there's no timeline for them other than they must occur after jurisdiction and disposition, or at disposition. So there's no real plan that says 60 days after the case is adjudicated there must be a treatment plan. But there can be, and treatment plans are often used as the primary basis for terminating parental rights. We established a treatment plan, the parent didn't object, the court signed off on it, and the parent didn't do the treatment plan. You're terminated. This is an opportunity to give parents some insight and some ideas about what treatment they need. Be involved in that discussion before there's a treatment plan. Get involved in treatment before it's required. There's nothing to say a parent can't start treatment. Have the social workers and parents discuss possible services and treatment for the parents. They may have had a team decision meeting. They may have had these discussions already, or they might have just met in the office or talked on the phone and come to some agreements. It's important to know if that occurred. Find out what it is they talked about and build on it. Have there been any agreements? There may very well have been agreements where the father said, I'm willing to do anger management. It's ordered in my probation. Can I get a referral? The caseworker calls up, gets a referral, and that's set for next week. What are those things that they've already agreed to? We're trying to get agreements here, but if there have already been some agreements, that's great. We take them down on our notes and we see if we can build upon those. Find out how long anger management is going to take. Are there other requirements for probation that we can deal with through referrals here? But know where we stand with services as we walk in that room. Has it started? Are the parents currently engaged in any services or treatment? They may very well have. The relapse example, the parent may well have gone back to their treatment providers, met with them, and they're re-engaged in an aftercare. Or they started to go to NA or AA, and they know about slips and getting those turned in. They've done things. They've gone back to a therapist that they hadn't seen in 6 months. Or they started back on their medication. I'm seeing my psychiatrist in a week about getting back on meds. I wasn't able to take my meds, or I didn't see the doctor, and here's what I'm doing. What are they doing? What do they think they need? What are they working on? And build from that knowledge. What does the social worker believe the parents need to be working on? And I throw that out there. They can't order at this point with a treatment plan. We're at the first court date. We don't have adjudication. We don't have a treatment plan. But what do they think? They've seen this case. They made a decision to remove the children because of safety concerns. They're professionals. What do they think the parents should be working on? In an ideal world, what would they be working on right now? How can we get that started? And then ask them looking down the road, what do you foresee if this goes successfully, if chemical dependency goes well? And we get a psychological evaluation and recommendations. What do you see? And they might talk about, parenting classes might be good. Get it out there. Don't let the parents be surprised and say, you told me I only had 2 things, and then you added 3 more later. Let them know that there are things coming down the road that may be needed, in addition to the ones we're talking about today. Do the parents want any referrals to services or treatment? Parents may want to start something, but they don't know where to begin. They know they need treatment. They know they need UAs to help them. They may know that and nobody has suggested it to them at this point. Find out if they think, well, I really need to see a therapist again. I did really well the last time I was meeting with a therapist. I made huge improvements, and when I stopped, it went bad, but my therapist left town, or I can't afford them. Can you get me a referral so that I can start up again? It is surprising how often parents will be honest and truthful about what they need and actually ask for help. And again, the trust factor, nothing reaches out more to the social worker than a parent saying, I need a referral for blank. And that the social worker being able to step forward and say, I can talk to the people at this office and get that done. What are the highest priorities? When we're talking about services, they're going to be likely immediate needs, things that need to be dealt with now, and things that will probably need to be dealt with later. Let's lay that out and say what we really need is to get parent off drugs now, to make sure they're clean and sober. Before we don't want a psychological evaluation while they're under the influence. That's a very common one. We don't want to have overnight visits when mom is actively using drugs. Now, let's find out what the priorities are and lay them out there and say, here are the things that need to be done now. In an ideal world, you would be working on this today. And down the road, we're going to be working on these other items. Do the parents agree to engage in these services treatments on a voluntary basis? You can't, as I said, you can't order this at this point. But one can say, if you want your children back, if that's your high priority, why wait? Let's get working on these things now. Can we agree that you'll do a chemical dependency evaluation? Often you hear, yes. Can we get a neuropsychological evaluation? Attorney might very well say, well, I need to talk to my client about that. And you say, well, will you agree to talk to your client and then get back to the caseworker, say, tomorrow? Sure, I agree with that. And get things moving. Set deadlines sometimes. Well, how long is it going to take to set that up? When can you get back to the other party? And give them ideas about this isn't just a day and then we come back to it on the next court appearance. Do the children need any services or treatment? Again, it's their case. It's the children. They may have needs related to abuse and neglect. They may have needs of their own. We need to find out again, and I think it's worth addressing it twice. As you see here, I've addressed it earlier in the children's portion, and I'm addressing it here. Did they need something? Because frankly, as we're having these discussions about treatment for the parents, things may ring. A bell may go off saying, you know what? My son could use something like this too. I have a teenager with drug issues as a child. Maybe that child needs to be on this too. How can we get services and treatment started? Meaning now. Okay, so the parents agreed to do some things. Or we've agreed that the children need some things to be worked on. How are we going to get that started now? Don't just leave it hanging there that it's somehow going to be done, but who's going to do the work? How's it going to happen? How's it going to get paid for? And when are we going to get going? Strike while the iron is hot. So things I have learned from pre-hearing conferences during the past 14 months. Having done this, I'm hoping that some of the mistakes I've made you can avoid by listening to the things that I've learned during the last 14 months. I guess it's also my hope that as other people start doing this, that we establish a network of people talking about how things go and what works and what doesn't work. So in general, the thing that strikes me immediately is that pre-hearing conferences and mediations in DN cases or child abuse and neglect cases are different in Montana. If you start out, like I did, looking for resources across the nation regarding mediation or pre-hearing conferences, a lot of times you run into discussions that are really about contesting the adjudication. and trying to mediate so that there are not contested adjudications. In Oregon, where I worked, and I did represent children and parents there, quite often the sticking point and the thing that needed to be mediated was, what are the allegations, what is provable by the state, and what are the parents willing to admit to, or are they going to contest everything? So oftentimes we'd end up in discussions that were about legal issues, not about what is best for the children. Where is the placement? What are visitations looking like? Our services. I view what we do here as far more productive, and I think it's pretty rare. I think, at least in our jurisdiction, I find it very uncommon that we have a contested hearing, although ironically there's one going on as I speak to you now. So typically what we're talking about are the big picture, the big issues, the things that I view as an ability for somebody to come in and help work on the things that could actually get children returned home and return home to a safe home. Or alternatively, to be placed in a relative placement as opposed to a stranger placement for either guardianship or adoption. That makes what we do much different than what you're going to research and find from, I saw things from Chicago and Utah and California, where they seem to be fighting legal battles rather than discussions about the kids. So I've noticed if you go out there and you're looking for material, you might find things that seem interesting, but maybe not so productive for the discussions we have in Montana. The pre-hearing conferences are not like any mediation I've ever previously facilitated. And what I mean by that is that you're in an unusual situation. Normally when I've been a mediator, either for domestic relations cases or in the case of, say, car accidents, the issue is sometimes money or property or things of that nature. Now, you'll sometimes run into a custody battle, but what you're usually running into is two people in an adversarial position. One wants something and the other wants the same thing. And you're trying to figure out ways to negotiate, to cut that pie. In the case of pre-hearing conferences, if people are actually following the law, we're in a place where we're really talking about reunification. It is still early in the case. It's not even jurisdictional at this point. And everybody should have the same goal, which is seeking to reunify the family. Only in the most extreme cases where somebody's committed a truly heinous crime or a truly heinous event are things going directly to termination, that there's not a reunification. So what you have is everybody in the room has the same goal, which is reunifying. But obviously they're going to have different views about how that is to occur. What's the time frame? What needs to be done? Perhaps who the child's reunified with. So by pointing out to people that they truly have the same goals, reunification, and reminding of that makes pre-hearing conferences completely different than other mediations I've worked on in the past. And it's been useful for me to keep that in mind as I've gone forward and to remind others participating of the same fact. Not everybody's going to like what you're doing. I think it would be a big surprise to me if wherever you are in Montana that you start doing pre-hearing conferences and everybody thinks it's the most wonderful thing in the world. I certainly did not run into that here. I heard that this is a big waste of time. I heard that we're being asked to do more work for the same amount of money. And you run into that as you're trying to get people engaged in conversation. There are people sitting there who are literally rolling their eyes. They're looking bored. They're looking at their watch. And I found that it took time by really engaging with the people and them finding out that I wasn't their enemy, that I was actually working on their team because, as I said earlier, everybody's trying to reunify. So I tried to get out that, what is the point of view of the social worker? What is the parent's perspective? What is the child's perspective? And it's taken time, and I'm still working on it. But what people are starting to understand is that useful information is being conveyed, useful discussions and agreements are being made, and people are getting on board with this idea, And obviously the fact that we're doing this video is an indication that people are getting on board. So you're doing important work. You're going to run into some resistance. Smile and keep going is all I can really say. Facilitators need to structure the discussions. I have been known to ramble, and you've probably heard that during today's lecture. However, I found it very important, at least for me, to maintain structure, since I'm not a person who generally does that. And compartmentalizing the ideas is something that I've come back to several times during these discussions. I found that very useful, and to remind myself that I'm the one providing structure. The parents have never, in most cases, been involved in a pre-hearing conference. They don't know what to expect, and you have to help them and provide that structure. Caseworkers just had one an hour ago get very upset at being lied about from their perspective, and trying to keep them calm and understand that this is just somebody else's opportunity to speak. If you don't provide that structure, you're going to have a loose train on your hands, and it'll actually be a counterproductive pre-hearing conference. People will come out feeling less likely that there's a team and that they didn't build anything. So that structure can be important to keeping the train on the tracks. Facilitators need to be truly neutral. You will be sitting there sometimes with people who have done some truly heinous things to children. It is inevitable, and it will happen frequently. And you're in the room with somebody that has done something truly heinous. There is no real question that they did. And they're a parent, and you're trying to put on this hearing. And part of you in the back of your brain is considering the fact this person really is a horrible human being. You will run into social workers that you view as exactly what parents sometimes think of them. And it's going to be difficult at times for you to sit there and be neutral. But the trust, and we've brought that up many times today, that is so important. And people can sense if you're not being neutral, if you're leaning one way or the other. You have to try throughout the hearing to maintain that neutrality. True neutrality, not just a perception, but the actual neutrality where you're attempting to be objective and neutral. People can feel it, people can see it, and if you don't do it, they will realize you're not being neutral. Hostility. You're going to run into hostile people putting on pre-hearing conferences. It's just an inevitability. As it says here, parents may be hostile toward the social worker. And that's going to happen. You have to remember, you're doing your day, and you might have been reading MSN before you came in, and you're having a normal day, and you come in there, but you're in a room with people who just had their children removed a short time ago. This is their first chance to really address that. And the pain is fresh, and the anger is fresh, and it's real. Now, there are going to be a lot of occasions where you can steer things back around to the key issues of placement, visitation, and services. But there are going to be other occasions where that anger is just there and you're going to struggle. One thing I have found is to just recognize their anger, to recognize their pain. Not try to minimize it, not try to put it aside, but just say, you know what, it's the most natural thing in the world for you to be angry. Your children were just removed. People feel this way every day in here. But it's not helping us any to get forward by focusing on that. We need to be moving forward and talking about the key issues. And this is your chance to talk and to be heard. And that oftentimes gets people back around to the key issues while just simply recognizing the fact that it's natural for them to be angry and hurt. Now, on the flip side of that is sometimes you're going to run into it with the social worker being angry. They've made a really difficult decision on some occasions. They've looked at a case and it might not be something simple where everyone would just remove or everyone would leave the children at home. And they've had to make hard choices. They've tried to look at this thing from every angle and make the right choice. And they feel very strongly about the decision they made, and they might be very defensive when they're in a room and a parent is being allowed to speak openly about the removal. They might lie about the social worker. They might lie about the situation. And you're asking that social worker to simply sit there and take it and then have their opportunity to speak. That is going to be a difficult thing, and it's something you have to measure. A lot of times I try to keep the social worker fairly close to me so I can sort of make eye contact or nod to keep them calm and quiet until their opportunity arises. Or sometimes I frankly had to interrupt and say, you'll get your chance, this is their time to speak. And you can have hostilities from a social worker who's defensive about the work they've done. They are overworked, underpaid, and they're being questioned. And recognizing it's natural for them to feel that way can also be helpful. Parents may not be highly functional, and this kind of comes in three basic things. They might be under the influence of drugs or recently clean from drugs. They might have mental health conditions in which they're struggling with their mental health, or they might have mental capacity issues. And sometimes, frankly, you deal with 2 or 3 of these during the same case. You've probably, at times, represented clients who are difficult, and hopefully you bring life experience in how to deal with people who are in difficult situations. And you're going to need all of that to run a pre-hearing conference. Because in theory, you have some highly functional people, and I will call attorneys that just for this video. But you also have in the room people who are struggling. Obviously, their children have been removed. It's good to figure out what the struggle is, sometimes to recognize it and to adjust. There are going to be times that you have to simplify things. There are times you're going to have to slow down. There are times you're going to have to explain more things. But keep in mind, it's not the lawyers that you're seeking to change. It's the parents' behavior. You're trying to help them to become functional, to be able to provide a safe and healthy home. So the key person, the persons that you really want to gauge your hearing to, is going to be the parents. And if they have low functioning issues, you need to adapt your hearing to that level and proceed along those lines. Parents and lawyers are going to show up late. You know that from your experience working in the law. What I found in my practice here in Yellowstone County is that I've got to go ahead with the case. I usually have very limited amount of time. For instance, this afternoon I had 1 hour to put on 2. I had people coming in late, and I just start. The lawyers in particular learn that I'm not going to wait for them, and that we're going to proceed. And if they want to participate, they need to be there on time, and they've learned that lesson, to be on time. Parents learn that lesson early because I do it in pre-hearing conferences. If somebody comes in late, I briefly give them a synopsis of where we are, and then we proceed. Otherwise, I think you miss an opportunity to have a productive pre-hearing conference because one person or 2 persons decided to be late. Locating missing parents. I've talked to you about how important it is to encourage parents to be there and social workers, because it's so key that the parents have an opportunity to hear this, to realize that there's a reason to be trusting, that the people that they're working with are people that really care about reunifying families. If they're not there, they really miss a true opportunity in their case to understand the importance, to learn early on what needs to be done. So if you have parents that are missing, there are people in the pre-hearing conference before you who are very likely to have information helpful to locating the people. You might have, say, a father who's been missing for several years and an attorney in the room representing that father. Any information that attorney or the social worker can get to help them locate that father increases the chance that that parent will have a chance to participate in the case. They may not want to. They may have abandoned the child. That's information that we need to know. But they may not know their child's in trouble. They may not know that the other parent was unable to parent successfully. They might very well want to be involved. In some cases, you may have a non-offending, non-custodial parent out there who's able to actually parent the child. And that's going to be key to know. So as much information as you can gather, the better. People may be reluctant to provide that information. You might have a parent sitting in the room with you who knows that there is a better parent, a parent who's currently fit out there, and they don't want you to know about that. They may justifiably think there's another parent out there who's violent, aggressive, inappropriate, and they never want their child to see that parent again. And that's a justifiable belief. Those are kind of the two extremes. And there are reasons why people might not be willing to give you information. But, as we said earlier, we're encouraging people like treatment providers, relatives, foster parents to be in that room. There is a strong possibility somebody in that room is going to have information that's useful for you. And hunt it out. Give that parent a chance to participate in the case, at some case, early rather than later. Social workers and lawyers need encouragement to find missing parents. You may be in a situation where there is little information. The parent may actually be unknown. You need to encourage the people, in particular the social workers and the lawyers representing these people who are missing, to make efforts to locate, to identify missing parents. For the same reason that they need to have the right to participate. What can happen is there are efforts made early in a case to locate a parent, and then the parent is not located and no further efforts are made until a point when maybe rights are being sought to terminate. This needs to be reasonable efforts or active efforts. Periodically, people need to be making efforts to locate missing parents. Not just check the box off early and assume they made efforts, but continue throughout the case. Things I have learned from pre-hearing conferences continued. Fortunately for you, or maybe unfortunately for me, there's been a lot of things I've had to learn in the last 14 months. The next general area would be focus of the pre-hearing conferences. And when I started this out, I try to follow a formula, and you see from the materials that you've gotten that there's kind of a formula for how to put these on. I realized early on that each case is unique, and there are often themes to a case, things that are far more important to discuss than others. There, maybe visitation is not a real issue, but placement, making sure placement is with a relative is something that people really need to talk about, and it's the key. It might be an Indian Child Welfare Act, and there's an issue about whether the case will be transferred to a tribal court, and that is the key that we need to be spending time on. As I told you, I spend time before a case researching and making sure I understand it, but sometimes I come in there and I just don't realize what the theme is. And I have to be willing to throw my ego out, accept the theme that's being discussed, focus on those important issues. And it may take the whole hearing. We may not get into all these areas. That's going to happen. But if you're having a discussion that turns out to be a key theme, the real issue, what is going on right now in the case, it's a good idea to just focus on that, make progress with that key issue in the time you have. And that's something I've learned the hard way. Parties may get off topic and stray into unproductive areas. And this is your structure. Things may be going fine. You're having a discussion about placement or services, and a parent may decide that moment, I don't care that we've been focused. I'm going to talk about how my children were taken from me in an inappropriate way and get back on that. You have to very quickly not let this stray into multiple people commenting on whether this should have happened or not. Remind them that you don't have a time machine. You cannot go back and change what happened. You can only go forward. Get them back on point as quickly as possible and as often as possible in some cases. But it's going to happen, and you have to be focused yourself for when it happens so you can quickly address it. Parties, on the other hand, may do a good job of focusing on the key issues, and this is another moment to get your ego out of the way. You may be sitting there, and all of a sudden this productive conversation happens. Exactly what you're hoping to occur by these pre-hearing conferences. People may be exchanging ideas, thinking outside the box, creating ideas. Sit back, take notes, and be happy, because this is what you're hoping to create. If you have a good pre-hearing conference, that's what you want to happen in the hallway. That's what you want to happen next week. And if it's happening right there in front of you, let it be. The Indian Child Welfare Act, ICWA. We've talked a bit about this and how it is important to discuss ICWA early in a case. I don't know that if I can emphasize this enough. But things like the rights of tribal membership and making sure that children get that membership. If this is a case and this kid's never had the opportunity to enroll in the tribe, make sure somebody's getting that done while the case is pending. This is a chance to make sure something happens like that. Active efforts are required in these cases, so make sure every relative is explored that is remotely appropriate. Take a look. Find out who's out there. You may find that some uncle that nobody really thought would step forward decides this is the time to step up. Are there other native placements out there? Does the tribe have ideas about where the children could be placed? It is hard to find an ICWA foster home. They are certainly very rare in the Billings area, and they're full. But thinking outside the box, finding people, you might make a big difference in these children's lives. Well, as I wrote here, explore the options for placement with relatives. That's the number one placement option, the highest level beyond placing with a parent in ICWA, is let's take a look at relatives, members of the family, and then we look further down the list. So along with every other case, you're always looking for relatives, and you're looking for relatives for options for visitation. It is exceedingly important in ICWA cases to explore relatives. Make sure communication is occurring with the tribe. Now, there are requirements that letters be sent out, and they're addressed to the tribe or the BIA, but go beyond that. Don't just assume that they've been served. Find out if people, in particular the social worker, is reaching out to the tribe. Whichever tribe it is, trying to speak with their counterparts within the tribe, the social workers there, working the idea and get the communication line going between the tribe and the people working in state court. Don't let it just be, we served them and haven't heard anything back. Children's needs. And I've brought this up many times today, and that to remember that the case is about the child. That's the caption in the case, is the name of the child or the initials of the child. Focus on that. Make sure you ask the parents about their children's needs. Oftentimes we have discussions where we're asking the caseworker, what are the children's needs? The caseworkers, while being hardworking people and having training, don't have the reservoir of knowledge about the children that parents do. The parents in general have been there, whether they were functional at the time, but they were there through these children's lives. They know things about the children that you can't simply know as a social worker or a foster care provider. They have information. Try to get them to provide that information so that we know what the needs are of these kids while they remain in foster care, and that we can develop a plan for after foster care. School can be a really big issue for children entering foster care. A lot of them, as we talked about earlier, have had problems with support in the home and schooling, but what the big issue can be that I didn't realize how huge it was till I got involved was changing schools. These kids have been removed from their home, removed from their parents. They've had a massive change in your life. And then along with that, quite often, they change schools. So their friends, their acquaintances are back at the other school. They've got a new group of kids. They have the normal problems of going to a new school and how hard that is for children, on top of the fact that they're not in their home. They're in a new home. You really need to take a look, other than to hear, oh, they're doing great, their homework and attendance are much better. Well, that's wonderful. But how are they really doing in school? Are they making friends? Are they involved in social activities? Are things happening after school where they're meeting people? Giving the children, we've talked about the parent support network, but giving the children a new support network in the new school. Making sure that people are there for them in this difficult time. Explore service and treatment options for the children in the school. We talked, I think, earlier about an IEP and trying to make sure that goes over, but there are counselors in school. These are trained professionals. They know these situations. We don't necessarily just have to rely upon the people in our room. There is a whole slew of experts at the school. Get them in the loop. Get the counselors in the school in the loop so they know what is happening in this child's life. They can talk to the teachers to make sure if there are any behavioral issues or academic issues, and they can stay on top of that. So somebody, and I would ask, who is going to make sure the school knows about this, whether it's the foster parent, whether it's the social worker, whether it's the counselor, but somebody is communicating with the school that we have a child here that is in a difficult situation. Here's what's going on. Here's their previous issues. Is there something the school can do to help? And finally, the goals for pre-hearing conferences. Early in this case, we talked about the purposes, but here we're really trying to talk about the things we're trying to accomplish. What did we try to do? What are we trying to achieve through the process of facilitating pre-hearing conferences? And again, can't say it enough. Establish trust between the parties moving forward. If you can do nothing else, and you can go in there and have people have a civil conversation, listen to each other, respect each other's view, and speak openly, you've accomplished something huge. It may not seem like it in the moment that you're putting one of these on, but you've actually opened the door to future conversations about what can occur with this family. How can it be reunified? And maybe you didn't make any steps toward that day, except to establish that trust. And if you establish that trust, you have made a big step. Introduce the parties, identifying everybody's role. It sounds strange, but remember, these are parents. Often they've never been in the system before. There's a bunch of people in this room. There's a bunch of people working on this case. There are lawyers for everybody. There's a guardian ad litem. There are CASAs. There's social workers. Just giving the parents a chance to understand who these people are, why they're there, and what they do gives a big step up on them feeling more comfortable about what is occurring. This is a difficult, hard situation for these parents. Having things that don't make sense or having it feel like people are hiding things from them is going to heavily impact your ability to get productive conversations going. If they understand the roles and know what people do and have a chance to ask, another big step that can be made. Focus on the best interest of the children. It's key in these conversations that you try to focus people on thinking about the best interest of the children. I'll grant you that the law can have minimally adequate parents and things of that nature, but what we have here is if you can get people, all that people in that room, thinking about what's best for these children. Because maybe it isn't keeping them in the foster home. Maybe it is sending them home. Maybe the social worker needs to say, this is different than my other cases. Or the parents maybe for the first time need to realize they're not the center of the universe. That they decided to have children or had children. and that they need to put their own needs in second place and put their children's ahead. That may not be the legal standard, but that's the standard that leads to children going home and staying home without a new case being filed, if you can get people to really think about that on a daily basis. Move the parties and the process from adversarial to cooperative. I think I used the word team a few times, and we've talked a lot about how to deflect people and get them back onto the key points. This is kind of that. It's that you come in the room, and we have our traditional legal system, which is adversarial, and served us well through history, but doesn't serve so well in a situation where you need to get people talking. Move it away. The adversarial system is there. People want to contest hearings. There is the courtroom to do so. But simultaneously, people should be working together to change things, collaborating, working together, a team. Identify the needs of the children and services to assist them in meeting those needs. The children are going to have needs, all kids do. And you're likely in a situation with kids who are abused and neglected that have higher needs or have their own needs. Taking the chance to talk about it and get that going during this case, that we're not just dealing with fixing the parents, quote unquote, but working with the children to help them develop their own skills to deal with their needs, can make a huge difference in the lives of these children. And focusing on it early and getting people to think about that can make it happen during the case. Discuss and reach agreements regarding the key issues. As I said, when we introduce this, we say, send out the attendance sheet and it's not an agreement. But if you can get people to agree and say, literally after you're done, agreed, and everybody nods yes, you say, okay, so we're all agreed that mom is going to do a chemical dependency evaluation, and it's going to occur at blank location next Wednesday. That's set up. Does everybody agree? Going back over it at the end of a section, for instance, at the end of placement. So we're all agreed that grandma will be explored as a placement option? Agreed. And getting it out there, making sure people understand that they actually agreed, that in a room full of people, when they had a chance to disagree, said, yeah, I will agree to do that. It is very hard to go backwards from a moment like that. People do. They usually don't get their kids back. But if they step up and they agree in that moment in time, it is hard for them to go backwards, and we have this thing moving forward. Discuss and understand areas of disagreement regarding the key issues. Equally important is if we don't agree. I don't think I need a chemical dependency evaluation. I just smoked a little weed a few weeks ago. I stopped doing that years ago. That can be a legitimate position of a parent. It may very well be the truth. And making sure that the parties understand. So we don't agree that there's a need for a chemical dependency evaluation. The state thinks they need it because of these concerns. The parent says they don't need it because of these concerns. You're going to discuss that further going forward. Yes? Yes. So outline the areas where we don't have agreement and make sure people agree to continue the discussion going forward. It may very well resolve itself with time. If a parent's abusing drugs, it's going to become clear relatively soon. If they're not, it's probably also going to be very clear soon that they're not exhibiting any indications of drug usage. Identify possible relatives and kinship placement. I've probably said that 5 times today in different areas, and I could say it more. If you have that type of placement, you have the opportunity for the family to work together, to have people working in a group. If the children do not go home, if it's a termination, an adoption, or guardianship, the children are placed with people they know in a family they know. I can't imagine what could be more beneficial to them than that opportunity. Identify resources for potentially increasing visitation. Kids are removed. They're in a new school. they have all this turmoil in their life, they need to have certain foundations out there to know that their parents are going to come see them, that they're going to see them on Tuesday, and that we can increase this, and that they can see their parents more, and hopefully in the process that they're seeing their parents changing, progressing, learning. What better lesson could a child have than to see a parent struggle and then watch their parent progress, watch their parent work hard to change their lives for the better. And that opportunity, and finding ways either through its therapeutic visits, relative visits, or whatever, but giving a child to see a chance that their parent can change. What better lesson could there be for a child? Gather input from the family and friends regarding the key issues. We've talked about this a little bit today, but having that support network there to keep people honest, about their history. Somebody may have had issues for 10 years and it's finally come to a head here. Or this may really be a new thing or one relapse. Having those people there not only to support the family, support the parents, but to keep the process honest through discussions, not only at the pre-hearing conference, but going forward with family group decision-making meetings and coming to court. It can make a huge difference on how honest the discussion is and how supportive it is. Gather input from the treatment providers. It doesn't always happen. These pre-hearings are early in a case, but sometimes you have a chance to have somebody there. And it's a real chance to hear what treatment looks like, where we are in the process, what's going on, are positive things occurring. You can get a real feel for a case from a treatment provider that you can't always get elsewhere. Identify and prioritize services parents might need. Again, one of the big things here and one of the true purposes of having child protective services is not just to remove children, but to make sure the parents have an opportunity to get involved in treatment, to get involved in services, that those services are appropriate to returning the children home, and that we prioritize them. That doesn't always happen on its own. Simply asking, what do we need to be working on now? What will we be looking at down the road? Suddenly gives the parents an idea of, okay, I'm going to do these two things, and then I'm probably going to have to do those two things, and then we're going to be having discussions about possible return. Just having that general idea without saying 2 months or some specific date, knowing when things are happening in order can make a big difference in a person's ability to do something. They understand that there's a light at the end of the tunnel. These are the things I need to do to get there. Discuss how those services might begin voluntarily. Again, there's no treatment plan at this point in the case. We haven't even adjudicated the case. But that doesn't mean we can't be working a plan for reunification. Why wait 3 months, 6 months? Begin now. Even if a client is contesting the jurisdiction, that doesn't mean they can't benefit or proceed with resolving the issues that are perceived by the state. Everybody can learn from these types of therapy and classes and just sitting through and listening to what a parenting class involves. Make sure people are getting involved. Give them a chance to volunteer. And if they don't, point out the timetable again. Well, if you wait for a treatment plan, it might be 6 months from now. And you essentially have a little more than a year to get things right. Would it be easier to start now and use the whole time, or do you want to use half of the time? Well, thank you very much for listening today. I hope this was informative. I want to take this opportunity to remind you of what I talked about earlier. I would ask that not only that you do pre-hearing conferences, but I would ask that you encourage your courts to consider putting on status hearings or status conferences. I can't tell you how important that has been to our pilot project, and that we don't just have a pre-hearing at the beginning, but we follow through, and that the court, there's the judge, the person making the ultimate decision in the case, engaging, finding out how the children are doing, finding out how the parents are doing, and what needs to be done. And The other item would be mediations. I do not only pre-hearing conferences, but periodically people request mediation. The judge wants a hearing, whether it's the ultimate issue, whether we could maybe do guardianship as opposed to terminating parental rights, or whether it's simply a matter of actually negotiating a contested hearing and whether this really needs to be contested. But I have found that to be exceedingly beneficial, and truthfully, these three things, the pre-hearings, the mediation, and the status hearings, are the things that have made the pilot project work and are the real benefits of it. If you have any questions, I encourage you to get hold of me. My information should be in the training manual. I would very much like to meet with you and talk with you. It has been pretty lonely out here doing this, and I'd love to have colleagues that are willing to work together. There are probably ideas out there I've never thought of, and I would love to discuss them with you. Thank you very much.